SJC-12439, Oxford Global Resources, LLC, v. Jeremy Hernandez.
Mr. Thomas, good morning.
Good morning, Mr. Chief Justice, and may it please the Court. My name is David Thomas, and I represent the plaintiff appellant in this appeal, Oxford Global Resources, LLC. This appeal fundamentally is about freedom of contract. When a person signs a contract, acknowledges that he's understood the terms, has had the opportunity to consult with counsel, and is not under any duress, generally that person is bound to the terms of the contract. Here, however, on a motion to dismiss, the trial court did not hold the defendant, Oxford's employee, to the terms of his employment agreement. In particular, the parties' forum selection clause, which obviously chose Massachusetts as the forum. In doing so...
Yeah, let me ask you that. The contract says, quote, governed by the laws of Massachusetts without giving effect to the conflict of laws provisions thereof. What does that last phrase mean?
I believe it means that it will be governed by the laws of Massachusetts without giving the effect of Massachusetts conflict of laws principles.
Okay, well, Massachusetts, part of the laws of Massachusetts involve choice of law. And is it your view that this contract overrides Massachusetts law that would dictate choice of law?
Your Honor, in this instance, no.
Okay, so you are saying, let's put aside for a moment the issue of whether or not the contract was enforceable because of adhesion. Let's assume it is enforceable. And let's assume then that it is to be heard by a Massachusetts court. Would a Massachusetts court then have to decide first, which substantive law do I apply? And apply Massachusetts conflict of law principles.
As to the extent that the Massachusetts conflict, the law would conflict with, for example, California law, the court could choose to apply California law to, for example, the contract claim in the case.
Okay, so, and arguably to the tort, is there a tort claim here?
There is a tort claim. There's also a trade secret claim as well, but the court could analyze the claims and apply California law to those claims.
Okay, so the issue is, and so the Massachusetts court could hear it, and the Massachusetts court could essentially say, I think because this contract was signed in California, and I know you would say that Oxford is based here, but that's a matter that the trial court would address.
Correct.
So the trial court then says, it is my job as trial judge to determine which law shall govern the substantive determinations as to contract and tort and trade secrets. And then there is a forum nonconvenience motion, and there the determination is based on the ends of justice. Is it your view that when this type of contract is signed, that this bars a party from moving to dismiss for forum nonconvenience?
I don't think it bars the party from moving to dismiss for forum nonconvenience. I think the forum selection clause in and of itself limits what the court can assess on forum nonconvenience. I mean, there's a substantial burden to get past the forum selection clause. It has to be unconscionable. It has to either violate public policy or deny the complaining party's day in court. What I think the W.R. Grace case, and I believe it's the Cambridge Bioscience case, states that when there is a valid forum selection clause, the court should not look at the defendant's inconvenience when assessing whether or not the forum is appropriate. Because obviously, parties can agree to a forum selection clause, and Massachusetts could have no relation whatsoever to the parties, and a court would not enforce that. That's not the case here, obviously. We have a Mass-based employer, California-based employee, who agreed to this clause. Our view is that the burden was on the defendant to put forth substantial evidence that that clause is not enforceable.
Well, is the determination for forum that's what I guess what I'm trying to figure out. But let's step back. Am I correct that you would argue that this clause would bar the plaintiff in this case from saying a move to dismiss for lack of venue? You would say that you can't move for lack of venue.
We cannot move to dismiss he can't challenge the venue. He's agreed not to do that expressly in the contract. However, in assessing, I think the court, in the face of a forum nonconvenience motion, first have to ask, is there a forum selection clause? If there is one, is it enforceable? And those standards should be governed by Massachusetts law, although the trial court did apply California law. I think Massachusetts law is a bit different. It's a little bit stronger. Once the court assesses that forum selection clause is enforceable, there is really a substantial burden to show that for some reason why a trial cannot be had in Massachusetts.
Okay, so you're saying that this does not bar a plaintiff. Again, I'm assuming for the moment the contract's enforceable, and in a moment I'm sure we'll address that issue. But if it is enforceable, your view is that a plaintiff may move to dismiss for forum nonconvenience, but that the burden is somewhat higher than it would be in the absence of this clause.
Absolutely, and the factors that the court should consider are somewhat limited. The court should not consider the plaintiff's inconvenience, or in this case, convenience in litigating in California, because there is an implied waiver, and that's in Cambridge Bioscience and in the W.R. Grace case. You can still look at public factors. I think the court can always look at a public factor. If there's a public policy issue, the court can always look at that, and I believe that is borne out in the W.R. Grace case, this court's decision.
Because ends of justice is one of the criteria with
Correct.
regard to that.
Correct.
Okay, so in that case, then, I'm trying to figure out, so if you say that the judge erred in saying it's not enforceable, then the result would be that this case goes back to the judge, and I guess you would say that the judge did not appropriately consider the waiver in allowing the motion to dismiss for nonconvenience, so it would be remanded for the purpose of the judge applying the appropriate factors in deciding the motion to dismiss for forum nonconvenience.
I think the judge did not apply the correct factors when assessing forum nonconvenience. Looked at the defendant's convenience, but also concluded that Massachusetts has little interest in this case, where we think that Massachusetts has a significant interest.
Isn't this case right on all fours with Taylor versus Eastern Connection? It seems to me it's almost the same case, which comes out your way.
And the Malia case, Justice Caffer. The Malia case is the mirror image from this court, I believe it's 2012, where essentially we had a Massachusetts employee, New York employer, employee sues under the Wage Act here for not being paid. The defendant from New York says, wait a minute, we have a forum selection clause and a choice of law clause in New York. This court ultimately said, well, that's fine. We understand that the Mass Wage Act is a fundamental Massachusetts public policy. However, certainly the New York court can apply the Wage Act. So we're going to respect the party's choice of forum, and that was the end result of Malia. That really is the mirror image of this case. It's the same exact situation, employee, employer, choice of law in a different state. This court respected the forum selection, and that's where I think the judge really came down incorrectly in this case.
But I understand Malia's the mirror image, but isn't Taylor the exact image? Taylor, we have it just seems like it's on all fours. Maybe I'm missing something, but you're not making as much of it as I thought you might.
I'm just going to refresh my recollection on Taylor, Your Honor.
Yeah, Taylor's the case. Again, it's another Wage Act case. Question presented in this case is whether in the circumstances individuals who live and work outside of Massachusetts for a corporation headquartered in Massachusetts may bring an action in Massachusetts court to enforce certain Massachusetts independent contractor wage and overtime pay statutes. And we say they can, even though all the business is in New York, right? It just seems like it's this case, but I'm sure your brother is going to distinguish it, but I just want to make sure I understand it.
It is. It's on all fours with this case. There's one exception, I believe, and the rationale is on all fours, and that's consistent with Malia. I think what my brother will say is that the defendant in that case is the one that drafted the forum selection clause and was challenging it. I think that's the distinguishing factor. But the reasoning in Taylor and Malia is consistent with how this court has enforced those types of clauses. And I think in both of those cases, there are forum nonconvenience issues as well.
Well, I guess along those lines, I'd like to go back to the Chief Justice's line of questioning. So assume that whether it's an adhesion contract or not an adhesion contract, there's no reaching the issue of whether it's unconscionable to enforce. And assume that the form selection clause is enforceable. So you've talked about the judge, as far as the statutory and common law issue of forum nonconvenience, not applying the correct standard. So let's say we're not considering how inconvenient it would be to the defendant to have to fly out here. Put that aside. Don't we have enough in the record as it relates to California law, to who the witnesses are, and everything else to say, well, it's not an abuse of discretion, even though it's a higher standard, it's not an abuse of discretion to say that the case is dismissed under forum nonconvenience as a matter of common law.
I think it is an abuse of discretion, Your Honor.
But you agree that's the standard we're looking at?
As far as what, I think the...
Not the statute, the common law and
Right,
statutory
the
issue.
common law, when a judge makes a decision on forum nonconvenience, if on the appropriate factors, I think the standard is abuse of discretion.
Okay.
And in this case, we would argue that the judge did abuse his discretion here. I mean, there's no evidence that the defendant put on. If you look at the defendant's affidavit, there's no evidence about witnesses not being able to come here, or if we couldn't get them voluntarily to come. There's no reason why we can't take videotape depositions and present that at trial. When we look at the forum nonconvenience analysis, the public factors, the court decides mass has very little interest. I think that's inconsistent with the case law. In particular, in this case, when you've got a Massachusetts-based employer since 1984, who agrees to employ this gentleman for 3 years and pays him, he gets the benefits of the contract. He agrees not to take confidential information. He agrees to tell Oxford if he's going to a competitor. He agrees to destroy information that he has. He also agrees that he will litigate the case here and not challenge venue. He did not abide by any of those agreements, so he gets the full benefit of the contract, whereas the employer gets nothing. I think Massachusetts has a very strong interest in enforcing this case because employers rely on these agreements, particularly employers that employ people out of state.
What do you think is left of the viability of the trade secrets exception to these non-compete clauses, and what's left of Edwards since we have the Dowell decision?
I think the way we read California law, when it's Dowell, Galante, and Edwards, California law will enforce and enjoin employees who use confidential information, whether it's a trade secret, confidential information, whether it's remembered or it's written, either under common law or a trade secret exception. I haven't seen a case stating that the trade secret exception is not valid, but that's just the exception to 16600. There is a common law claim, there are tort claims where without a non-compete, California case law would enforce it if the employee is competing unlawfully. And unlawful competition is using confidential information to solicit business incorrectly. Oxford is not trying to prevent this, Mr. Hernandez from competing lawfully. He left in April 2016, I believe. Oxford didn't sue him. They sent him a reminder letter saying, abide by your non-compete. Oxford only sued after getting information from someone from MindSource with pictures of their information on this gentleman's workstation. That's when they sued, and the injunction that we seek is just don't use our confidential information when soliciting our customers. If you're going after companies that we do business with and you're not using confidential information, you're not going after our managers that you learned of here and you know their likes and dislikes, that's fine. But please don't use our confidential information because that's what you agreed to when we employed you. And that's, I think, the difference. I think California law is fine. We think we can try the case and win it under California law. That's separate than the forum selection issue. And the court, Malia addresses this too.
Yeah, but maybe it's making it too complicated here. The section, 16600, is that how you refer to it?
Yes.
Okay. Section 16600, if that's not what we're dealing with, but we're dealing with not a trade secret exception, but the enforceability of a trade secret provision, well, when we take a look at these manager lead sheets, that's going to make a big difference as it relates to the enforceability of the forum selection clause, because a lot of the argument by the defendants about the inapplicability of that provision revolves around this section 16600.
I understand. I think it's a red herring, actually. And the reason is this. After going through that analysis, and I know there's a lot of briefing back and forth on that issue, the trial court concluded that the issue under California law and its scope has no relevance to the forum selection because the Massachusetts court will apply California law. It's only when the forum selection clause and the choice of law clause work together, and Malia addresses this, to deprive someone of their rights under California law, for example. And Malia recognizes that with modern choice of law principles, that rarely will happen. And the court has concluded already, the trial court has already concluded that California law will apply. So there's no concern that the forum selection clause in and of itself somehow is going to deprive Mr. Hernandez of anything, because it'll be tried in front of a Massachusetts court, obviously if remanded, and it stays there. And California law will be applied. We're, again, happy with California law. We think we'll prevail under California or Massachusetts law. And on that point, we do think that the trial court erred in its conclusions about the scope of what we were trying to protect and how the law impacted it. We have a verified complaint that was entitled to some deference at the pleading stage. And again, we're not at summary judgment. We have pages and pages of allegations about how this information is built and protected, and really didn't get the benefit of those inferences of those facts on the motion to dismiss. So I do think that all of the argument back and forth in the briefing about the impact of California law on the actual claims has no bearing on the court's decision under forum selection, and that's what the court concluded in its decision towards the end.
If I could ask you about forum nonconvenience.
Yes.
If, and again, we'll hear from Mr. Scheer, but let's assume for the sake of argument that it will be heard in a Massachusetts court, at least initially, and that Mr. Hernandez may move to dismiss for forum nonconvenience. In deciding that case, is it part of what a judge may consider in terms of determining the ends of justice? If the state law that is being applied turns out to be uncertain or relatively complex, is it within a judge's discretion to essentially say, golly, I'm now being asked to decide what is a cutting-edge decision of California law? I think that's a reason why this really should be tried in California, where an appeal of my trial court decision will go up to the California appellate courts as opposed to the Massachusetts appellate courts. Is that something that a judge may consider?
I think a judge certainly can consider that. In this case, the judge has considered it and has concluded that a Mass court is more than capable of applying California law in this case. That's part of the decision. I don't think this judge will shy away from making those determinations.
Okay, thank you.
Thank you.
Mr. Scheer?
Thank you. Good morning, Your Honors. My name is Barry Scheer. Along with Lisa Scalisi, we represent the defendant appellee, Jeremy Hernandez. Mr. Chief Justice, members of the court, I think you're going to hear a lot of technical arguments, and you already have, and we've briefed a lot of technical arguments with various factors. But as the court has recognized, there's a couple of overriding concepts. And the first is set out in Massachusetts General Laws, Chapter 223A, Section 5, which governs forum nonconvenience. And it's a very simple and elegant statement that says that a court may dismiss a case in the court in the interests of substantial justice. And I think that if it's good to keep that in mind as we listen to the arguments, because ultimately the decision should always come down to whether substantial justice is being done. The other point, and perhaps this doesn't need to be made forcefully because I think the court understands this, is that this court has said that the decision as to whether to dismiss on forum nonconvenience grounds, it lies within the discretion of the trial court, and that should rarely be undone.
In exercising the discretion, can the judge, what's the role for the judge in considering the forum selection clause? Let's say that there's no reason to say that the forum selection clause is unconscionable or a burden or unfair. I'm not saying it is, but does the judge factor in the existence of this forum selection clause in exercising his or her discretion?
I think the judge does, and I think in this case, the judge did. And just so it's clear as to what the standard is on forum selection, we're throwing around terms such as unconscionability and adhesion and fairness, but there are various tests under which a court can find that a forum selection clause or a choice of law clause should not be enforced. And while unconscionability is certainly one, the other is whether it's fair and reasonable under the circumstances. And in this case, the court found that it was not fair and reasonable under the circumstances, and that's a legitimate finding of the court.
Based on what? You agree it's your burden to show that, don't you?
Oh, yes, yes. And so here's the basis. Starting with the choice of law clause, because I think that's the threshold inquiry here. If you start with the choice of law clause, and I think the court has touched on these issues, you have to look to see whether the application of these provisions contravene a fundamental principle of another state, in this case, California. California has clearly indicated that this is fundamental. And when I say this, I mean Section 16600. This is, under California law, the courts work very hard to protect the employee under the dictates of Section 16600. Not only are contracts void if they have language in them that have any non-compete or any non-solicitation language, the contracts are also unlawful, and the employee has the right to sue the employer under California's unfair competition law under Section 17700. So the mere fact that the language is in one of these contracts makes it unlawful and gives the employee certain substantive rights.
Even if the employee is violating other parts of the agreement, meaning, my understanding of California law is that you can't walk off with these kinds of lists that have this kind of detail in them, and therefore you may be in violation of them. So if they have extra provisions, that makes the whole thing unenforceable, or do they blue line them, or whatever the proper terminology is of these kinds of restrictive covenants?
Your Honor, it's, as was pointed out, this isn't absolutely crystallized within the California courts yet, but in answer to your question, the contract can be void. It doesn't in any way impact an employer's right to seek damages or injunctive relief under either the UTSA, California's Uniform Trade Secrets Act, or under tort. But if you read the California cases, the line of California cases, not only Edwards and not only Dowell, but Galante, each one of these courts has said we doubt the viability of the trade secrets exception under 16600. And the reason I mention the fact that the employee has this right to counterclaim or bring a separate action, it's twofold. One is because by applying Massachusetts law, we are depriving the employee of the right to countersue. This is a substantive right guaranteed by a fundamental policy of California. We're also requiring the employee to lose all of his rights under California contract law.
Well, I have a basic question about that I should know the answer to. So if the forum selection clause is enforceable, does that by definition mean the choice of law provision is enforceable?
No, but here's.
I didn't think so.
Here's the problem I think that we run into. I think that we get to a point where we have an absurd result if we, and again, there's a little bit of an analysis in this, but the issue is if the choice of law provision is unenforceable. Let's say we now have Massachusetts court applying California law. In addition to the issues already raised, which are really legitimate issues, is a Massachusetts court, for instance, going to make the determination as to whether the trade secret exception is still viable? So that's.
But isn't that
one
exactly
reason.
what happened in Taylor versus Eastern Connection? We have this complicated Wage Act law, and we had a choice of law in New York, a choice of forum New York, and we were comfortable, this court, not that long ago, in sending that to New York to decide, including the Massachusetts Wage Act issue. So I don't understand why Taylor doesn't control this.
As my brother pointed out, and quite rightly, in Taylor, you have the employer's forum selection clause. The employer drafted it, and here it's a very, very different situation. We have a contract of adhesion, and I'll address that momentarily.
Although, yeah, I mean, but we've said these kinds of contracts are enforceable. I mean, I don't understand where the trial judge's interpretation of contract adhesion even comes from.
Well, a contract of adhesion should be one of the factors that we look at. Now, agreed that it's not the factor that by itself will put this over the top.
Right.
But when you have a contract of adhesion and it's tied to an unfair and unreasonable provision, and the unfairness and the unreasonableness comes from trying to or the result of contravening a fundamental policy of another state, you put those together, and that's where you get the lack of fairness and the lack of reasonableness. And that is the standard when we look at the underlying clauses here, the forum selection and choice of law clause. But to get back to the analysis, so we have a Massachusetts court looking at California law. And as I mentioned, that's one of the factors that Massachusetts is going to be called upon to make these very subtle distinctions and come up with a determination as to parts of California law. The other piece, which I think is even more persuasive, is that if the under Dowell, and there's a later case called Western Air Charter, which wasn't briefed because it just came down after the briefing. In these cases, the court held that if the language of a confidentiality provision is too broad, then the contract is void ab initio. So I'm not saying that this court has to make the determination as to whether this contract was void ab initio, but it is a substantial likelihood that that would be the finding. In addition, you have
The whole contract?
the whole contract
Severability?
is void ab initio. Now, and that's, if you read Dowell, that language in there, the Superior Court voided that contract ab initio. It was affirmed on appeal. If you have that situation and the contract is void, you then have a Massachusetts court applying California law to California's statutes, not the contract, because the contract's out. So you have Uniform Trade Secrets Act, you have the unfair competition law, you have California statutes that Massachusetts is applying. And that wasn't the purpose of the forum selection provision. The forum selection provision was to govern the contract and actions growing out of the contract.
Well, the
So
forum selection, I know the trial judge says the forum selection is to sort of impose this Massachusetts on California, but it's a Massachusetts headquartered company with employees in all kinds of states, right? And I assume it's their form contract that they make everyone sign. Is that not correct, or is that incorrect factually?
Interesting, it is incorrect factually.
Okay.
If you look at this particular contract, there is language in there that goes directly to California, to the California employee. And if you look at the legend at the bottom of the contract, it references the fact that this is their California contract. As was pointed out in the amicus brief, Oxford has actually filed cases in other jurisdictions. So I don't think that this is...
So in other states besides, when they're hiring people in other states besides Massachusetts, they use other states' laws? Or do they always write, this is our provision, it applies in California or whatever state it is? I'm just trying to understand whether are you saying they've targeted California because they don't like California's covenants?
I wish I had that information,
Right.
but I think that the judge, if you read the judge's decision, he found that based upon all the facts, that's exactly what Oxford had done, that California, and as this court knows, California has very different laws when it comes to employment. And
would it matter that your client, who's in the tech business, I mean, even us Neanderthals know that California and Massachusetts have different provisions regarding the ability to mobility. Someone who works in the tech industry wouldn't understand that either when they sign this contract? I mean, I understand he's a new employee, but this seems to be something that you know when you go into the tech industry.
Well, I think in California, as you mentioned, it's very different, number one. Number two, as the court found, and as was pretty much admitted in the plaintiff's papers, you have an entry-level employee with virtually no skills when he entered. And on that basis, the court found that this was, in fact, a contract of adhesion. This is very different than the Carnival Cruise Lines cases, where there are, the possibility of thousands of cases, and the cruise line wants all the cases to be heard in the Southern District of Florida, because they do have an interest in making sure that there's some uniformity. Here you have a much more closed set. They're drafting contracts that are specific to the states, so you don't have that same situation. And with what is clearly a contract of adhesion. I'll just mention...
On that score, can you help me? The judge cited the ALI provisions on contracts of adhesion, where he talked about misrepresentation, duress, undue influence, or mistake. And then it also talks about a take it or leave it provision in a contract with a weaker party with no bargaining ability. Examples are tickets or insurance policies. In every contract, entry-level employment issue, and this is something that trial court judges see all the time in these trade secret non-compete cases, I'm sure you've litigated, isn't it always a take it or leave it? I mean, can't the person walk away? How does that get to be a contract of adhesion? What are we supposed to look at?
Well, I think that in executive employment agreements, there's certainly a difference. The employee will have substantially more ability to negotiate, maybe not the agreement itself, but possibly the term, possibly garden leave. I think there are distinctions between an entry-level employee who has no skills and one who is in the industry.
Maybe I'm trying to get you to be too categorical. Are all entry-level employment contracts, in your view, take it or leave it, that fit this category?
I don't know that I could answer that. I think it would have to depend on the particular situation.
What makes
and the
this one?
particular
What about this case?
contract.
What makes this a take it or leave it, a contract of adhesion?
Well, in this case, you have these provisions, and the plaintiff himself has indicated, or the plaintiff itself has indicated, that he would not have been given the job had he not accepted the contract. So that makes it a take it or leave it agreement certainly, I think factually, that's what it is. And again, I'm not saying that.
Where's the duress, misrepresentation, or undue influence in that situation?
The court itself, the court below, found that it was the unequal bargaining position that caused the
But I think,
duress.
isn't it true, though, I think maybe I'm misinterpreting Justice Gaziano, but that any entry-level employee in any situation is always going to be vulnerable to this, so would every contract with an entry-level employee be an adhesion contract?
It may very well, but oftentimes it's not an issue as to whether it's an adhesion contract because we don't have the types of issues that arise here. And remember, we're not basing our argument on the fact that it's an adhesion contract. I think it's one of the factors to be taken into consideration. I think we're basing our argument on the fact that we are depriving an employee of the substantive rights that he has under a state who has a fundamental policy to grant those rights. And that's really the crux of the argument.
Mr. Shearer, if I could ask you one more question. I'm sorry to go back yet again to the common law issue on the
sorry, Your
dismissal.
Honor?
The common law, forum nonconvenience
Yes.
issue, the common law issue. And with the same prefatory remark, we don't know where we're going to come out on this, but let's say that the judge was wrong on the enforceability of that provision, of the forum selection clause provision. And let's say that that he was wrong on the reasons that he dismissed as a matter of common law and on the statute. And that he was taking into account this unequal bargaining position, this unfairness, the inconvenience of people in California. Can we look at the entire record ourselves and look at whether or not, based on that record, it would be an abuse of discretion as a matter of common law to say that the matter should be dismissed as in inconvenient form?
I don't believe so, Your Honor, for the reason that if you look at the language in the W.R. Grace case, there is language in there that suggests that a private agreement can never supersede the public interest of a state in dismissing a case for forum nonconvenience. So we always have the ability to look at the public interest in making these determinations. And as this court has already noted, we have issues of compulsory service of process in California that would be very difficult.
I think I need to ask the question better. If the judge's reasons for dismissal as a matter of common law were not well grounded in the case law, can we nonetheless look at the entire record de novo in considering whether or not this is an inappropriate forum?
I believe that this court has that power, yes.
I could ask one more question. Let's assume for the matter that you're right. Let's assume for the moment that you're right, and that this is an adhesion contract or for whatever reason is not enforceable, at least as to those provisions. They brought the matter in Massachusetts. So what difference would it make in practice? The case would be brought in Massachusetts by them. Judge would apply a choice of law and arguably could determine that the appropriate choice of law is California. You argue dismissal for grounds of forum nonconvenience. Does it matter? Apart from the issue that your brother raises, which is that it may be a factor in the determination of forum nonconvenience, but they still brought the matter in Massachusetts. It's still filed here.
Yes, and then I think you look to the traditional forum nonconvenience test. If California law applies, it's an either-or. If California law applies, I think you have to look to the traditional forum nonconvenience test. And I think if you look to the traditional forum nonconvenience test, if you look at suitable forum, if you look to who has the greatest interest, if you look to the private interest, which, by the way, I think you can look to whether there's a forum selection clause or not, and you look to the public interest, I think that it will overwhelmingly come out that this case is properly before the courts in California, who, and just for a couple other reasons. One is that California will be applying California law. Two is California appellate courts will have jurisdiction over. And three, if there is an enforcement action, you have that problem of having the California courts look at this different than the Massachusetts courts and run into problems with enforcement as well.
And if for whatever reason the judge were to decide that the matter can be adjudicated here and applies California law to it, is there anything that would bar you from filing an action in California invoking the statute that says that it's essentially unfair practice for them to have done this contract?
Well, I think you run into the problem of having one court in Massachusetts saying, no, this is the contract is a lawful contract, and at the same time, another court in California saying the court is not a lawful contract. And I think you would have an issue there with the two courts.
So you might have
looking
re
at the contract
judicata
in two
issues,
different
but is
ways.
there anything that would bar you from bringing that claim?
I don't believe so, no.
So it's not as if you wouldn't be able to argue you're entitled to damages, you just have to do it through a separate claim, through a separate action as opposed to a counterclaim.
Yes, except that we could end up with inconsistent results in Massachusetts and California. And it would seem to be absurd when this can all be dealt with in a single court, hearing the same evidence, using the same law, and ruling on the same issues.
All right, thank you.
Thank you, Your Honor.